bad?
Good.
Good, okay. Anyone else hiding on the other side? I'm not sure. Okay, so kind of actually probably a newer group. It sounds like a lot of people are newer agents in this office, and even a lot of the more seasoned realtors, it sounds like, haven't had any experience with probate. Some people sounds like on a personal level, so this is good. So I'm gonna keep it relatively basic then. So what I want to do then is just start with some key definitions. The definitions that I'm going to use here are really the primary words that you'll use as a realtor. And so I'm coming at this. The presentation is really from the point of you're getting a listing, right? So this is really, a probate hasn't been started yet. This is, the example throughout this kind of, this presentation is someone calls you, let's say, and they say, hey, John, I've got a friend. They want to sell their house. Okay, and that's kind of like where we're starting from. So probate. What is probate? When you think of probate, or when I think of probate, the way I think about it is that there's courts, there's judges, there's attorneys. Someone has passed away. That's really when probate starts. Probate comes after someone has passed away, and what you're doing is you're taking what they had while they were alive, and you're going through the courts, you're going through this, basically through the court system, and at the end of it, the judge is going to say, okay, now these people are the owners of it. And so in your case, in real estate, someone owns a piece of property, John Smith owns a piece of property, he passes away, now his children want to sell the property, you've got to go through the probate process to be able to sell it, and the judge in the court is going to say, okay, now the new owners are, his children, they can sell the property. Decedent. And I should say, if you all have questions, please just shout them at me. Whatever. No need for formalness here. Decedent. So what is decedent? Decedent is just another word we use for someone has passed away. A dead person, right? Yeah, and we are talking about a serious subject, so I try to keep it light as possible. A dead person, someone who's died. Estate. So the way to think about estate is really everything that the person had. So when John Smith was alive, he owned his car, he owned his house, he had his bank accounts, he had his clothing, jewelry, whatever. All of that was owned by John Smith. John now dies. All of that stuff, the car, the bank accounts, the house, everything is owned by his estate. So now everything is owned by the estate of John Smith. So when you hear the word estate, you can just kind of think it's everything that is owned by someone who's passed away. That's really the new owner right now. Last will and testament. Anyone know what a last will and testament is?
That you prepare before you die.
Okay. And what's it for?
For don't have the problems to go to court and put the kids through struggles, some fighting, some family.
Antecedents instruction.
Yeah.
Which a person expresses how they wish to.
Nailed it. Good.
But it had to be notarized.
The answer's right here.
Yeah, so there are some requirements of what makes a valid will, and so it's not really your job to determine whether or not a will is valid or not. There are, generally it needs to be, there needs to be witnesses, and there's some other requirements. But a will basically is a person makes that while they're alive, and they say what they want to happen with their stuff after they pass away. Okay. Personal representative / executor. This is probably the term that you all will use most commonly or most frequently, because the personal representative is the person you would be working with. I put the word executor on there because some states use the word executor. I know New York does. But when you hear the word personal representative, when you hear the word executor, they mean the same thing. And the person who is the personal representative has the authority to sell the property. They're the ones, if there's no personal representative and you're not working with the personal representative to sell the property, you're not working with the right person. And the person becomes the personal representative once a judge says that he or she is the personal representative. And we'll touch on that a little bit more. But those are the basic definitions. Okay, so in front of you, you all should have 3 different handouts. So I kind of gave away the answer here, but so for the newer realtors, what's one of the first thing, or maybe the more experienced realtor, yes?
All those handouts?
They were all up here, yes. So when someone gives you a potential listing or says, hey, they've got a property for sale, what's one of the first things you all do? Go to the tax roll. And for the newer realtors, that's something you probably should do. And why do you want to do that? Yeah, you want to make sure, you want to find out who the owner is. Because if you're talking with Dave and you go on here and the owner says Sarah, you might have an issue. So similarly, when you're determining whether a property needs to go through probate or a probate is necessary, you're going to be able to, the easiest way to tell is by looking at the tax roll. So I want to talk first about if we could look at property address 11309 Southwest 200th Street. Okay, so this is the most common way that you're going to find out if a property needs to go through probate. So if you look on there, you see owner Maria Pichardo, EST of. Anyone want to take a guess what EST of? Estate of. Yeah. So when you see that, I would say when you see that EST of, it's usually going to say EST of. But when you see that on there, I would say 95% of the time it means that you're going to have to do a probate before this property could be sold. And that's what happened in this one. So Maria, she passed away. Her daughter wanted to sell the property, but she couldn't do anything until, this is one actually we did, but she hired us, and we went through the court system, and the judge said, okay, Anna, you are now the owner of the property. You can sell the property.
Do they need to go to probate if they want to rent it too?
Yes. Yeah, they do. Yes, sir.
So, before Maria passed away, the tax records read just Maria Pichardo.
Yep.
And then the tax records were updated based off death certificate, and then changed to estate of.
Yeah, so there's no, I've looked and I've asked around, there's no rhyme or reason of when or how the county will update the records. I would say, so there's a government organization in Florida called Vital Statistics. They're the ones who do the death certificates. We've spoken with Vital Statistics. They say that they mail the death certificates to the county, and that's one way the county might update them. Another way is, a lot of times what people will do is this, I don't remember if this is the case in this one, but let's just say her daughter wanted to live in the home, or maybe wanted to keep it as a second property, but she wanted to keep the homestead exemption, right? So she contacts the county and says, hey, my mom passed away, I want to get, the county stops listening after that. They just see that she passed away, and then they're gonna update the records and say that it's now owned by the estate. I think maybe the mortgage company might have something to do with it, but I don't really have the exact answer, because I've seen it where they've updated the records pretty much right away, or I've seen it over a year and it still shows, it doesn't show that it's estate of. But for purposes of this, when you're looking at the tax roll and you see that EST of, that is going to generally mean you've got to do a probate before this property could be sold, and just that's maybe 102, probate 102, but for renting a property as well, yeah, you need a personal representative appointed to be able to rent it. Any questions on that one? Okay, yes, sir.
If the property's under a corporation name?
I will answer that. But generally, if it's under a corporation, no, it's not going to need to go through probate. No. All right, let's look at the second one here, 1821 Northwest 33rd Street. Okay, so on this one, you're going to see two owners, or what appears to be two owners. So you're going to see Jesus Silva, EST of, and Maida Silva. Okay, this happens a lot in Miami, where you have two owners. Were you gonna ask something or no? No. Okay, sorry. Okay, so this is again real life example, and this is something to be cautious of or aware of. So Jesus is the father. His daughter is Maida. They own the property as, and again, I don't want to get too much into the title world, but they owned it as tenants in common, meaning Jesus owned it 50%, Maida owned it 50%, okay? Jesus dies. They changed the record to reflect Jesus Silva EST of, which now we know means needs to go through probate. Maida is the only daughter of Jesus. Again, she was already on title because she owned 50% of the property. So Maida gets a realtor. They spend like 4 or 5 months marketing it. They get a seller, or they get a buyer. They go to the closing table, and the closing agent says, "You got to go through probate for your dad." And she didn't know. I mean, the realtor didn't know. I mean, they probably just. I think she just thought, "Well, I'm the only child. I automatically get the property. I'm already on the title. Why do we need to do a probate?" But because they owned it as 50-50, they had to do a probate. So we ended up having to do a probate just for Jesus to get the property put in Maida's name so that Maida could sell it.
But if you had a tenant who right of survivorship, then probate
Yeah.
doesn't
So
happen, right?
the way to have avoided that is they could have owned it as joint tenants with right of survivorship, which basically just means when one of the person passes away, the surviving person is going to inherit the other half. So if Jesus and Maida had owned the property, and they would have had language on there that said joint tenants with right of survivorship, when Jesus died, his 50% would have automatically passed to Maida, and they wouldn't have had to do the probate.
Life estate?
Life estate, yeah. Life estate as well.
Does that reflect
Remain-
on tax
remain-
record?
Yeah, that will reflect on tax record. With the joint tenants with right of survivorship, it's going to be abbreviated. It's going to be JTWRS, I think is how it will show up on there. So the other way to avoid this, one of the more common ways to avoid this is if we look at the last example that I gave you guys, 13926 Southwest 161st Court. So this one is owned by Karen S. Rodman, and then in parentheses, or not parentheses, then it says TRS. Anyone want to take a stab? What's TRS? Trust. You guys smart crowd. Yeah, so trust. So a trust is a legal document that is becoming a little bit more common. It's a more sophisticated document or thing to do, but you can you can start a trust. So I don't know the name of her trust. I didn't do this one, but I'm guessing it's Karen S. Rodman Trust, dated whenever she did it, August 20th, 2017. And then she did a new deed, and she put the property into the trust. Basically, did a new deed saying that the owner of the property is now the trust. And then the second part on there, which I'm not exactly sure if it's the same Karen or if it's a daughter, or what the trust says, but that BEN stands for beneficiary, which means who gets the property. Essentially, is what that is. So this is a way that to avoid probate. Yes, ma'am.
Does the property have to be free and clear, or can it have a mortgage?
Generally, it does. Generally, it does need to be free and clear, and that's somewhat lender specific. Some mortgages will have a clause in there that will say, if you change title from this, the whole mortgage is accelerated and all of it is due. But I've seen them done both ways. I've seen them when there is a mortgage. Generally, though, there is no mortgage on the property. Yeah. Anything else on that? But so this is trust. Again, you all would not be writing the trust. An attorney's going to draft the trust. You all probably shouldn't draft the deeds either. Your title company, your real estate attorney, whoever's doing that is going to draft the deeds as well. This is more so just to when you see a property and it's got some of this language on there, you can kind of start thinking the analysis of what you need to know when you go in, and in this case, go for a listing presentation. So this way you can maybe do a little bit of research. Yes, sir.
I want you to address having an existing mortgage on a property and what the lender's position may be and what kind of latitude it could possibly be. Because obviously there's a reoccurring debt, who's paying the bill. Due on sale is obviously there,
Mhm.
all mortgages as far as I know. But what becomes sort of the norm? How do they handle this? The mortgager, because it's gotta be left to somebody. So if Pop died and he left it to the kids, or somebody's taking it over, what happens there? Do they just automatically allow the son to make payments on it, keep it in the father's name? What's the
Yeah.
transition liability, et cetera, man?
Yeah, good question. I'll answer it just because it's fun for me. But yeah, yeah. So that's a good question, and that happens a lot. That happens a lot where, you know, because mortgages are 30 years and people do a refinance or they take out a home equity line of credit. So most properties are going to have some sort of debt associated with the property. So generally what I tell people is don't let the lender know that they've passed away, because I've seen it where they'll stop accepting payments and then they'll start the foreclosure process, and we'll talk about length of probate, but sometimes if they take longer, you could end up losing the property to foreclosure, whereas you could have kept making the payments. I've seen it where if the people inheriting it are able to make the payments, I say keep making payments, because they're going to, at some point, they're,
Without any notification to the lenders.
yeah, yeah.
Just continue making payments in your father's name, so to
Yeah.
speak, and go on with it.
That's my recommendation. That's generally what I advise them to do. Not all of them, and again, this is completely lender specific because I've seen it in other ways. Not all of them will stop accepting payments. Some will just keep accepting payments. Some have them automatically debited from the person who passed away from their bank account, so they don't have to worry about it. Does that answer it, or?
Yeah, sort of. I mean, if you decide to keep the property, that's what you're gonna do, I guess.
Right.
And if you're not gonna keep the property, you wanna keep on making the payments until you liquidate the property.
Yeah, exactly. Yeah.
What are the tax consequences and or benefits attached to something like that by doing it? Someone's gonna be making, who's gonna be taking the tax benefits from making all those payments?
A little outside the scope, but I mean, I think what I would say is, it's almost like you could think about it, it's just either the person is going to inherit it, so they're getting the tax benefits because the property is for them, or sell the property as quickly as possible. But yeah, it's a little advanced. We'll do a 102 for that one. But yeah.
Quick question.
Yes, sir.
You do trusts and wills and things, or you just handle the probate afterwards?
We usually do the probate, and then when the client comes to us and they say, how could we have avoided this, and then we'll do the wills and the trust for them as well.
Another question.
Yes, ma'am.
How long take to close out probate?
I'll touch on that here in a second. Yeah. Okay, so that's the easiest. Obviously, if someone says, hey, I've got a friend, their mom just passed away, they want to sell the property, you start thinking probate. But these are just a couple of ways to identify whether or not a probate is going to be necessary. So, okay, section number 2, you have determined that probate is necessary. So now what do you want to do? You've got a listing presentation with the person. I always tell realtors you want to ask really 2.5 questions. So the first question you want to ask is, did they have a will? So did the person who died, did they have a will? And if they say yes, I say, can you get a copy of it? And here's the reason why. Again, this whole section is about don't waste your time speaking with somebody who has no right to sell the property to begin with. So you want to ask, do they have a will? And the reason is, in a will, you can leave the property basically, there are some exceptions, but basically to anybody who you want. So if I want to leave the property to my cousin, I could leave the property to my cousin and say in the will, my cousin gets the property. But let's say you're speaking with, well, let's not use me as an example, but let's say you're speaking with someone and it's the daughter of the person who died. And she's the only daughter, and you're confident, oh yeah, she's going to inherit the property. It's definitely hers. His spouse had passed away, but you find out there was a will, and in the will, he left the property to the cousin. You don't want to waste your time speaking with the daughter, even though she's the closest living relative, if the property is going to be inherited by the cousin. So, again, your job is not necessarily to dissect the will and read and find out, is it a valid will and all of that, but you do want to have an idea if there was a will, so when you go to your attorney or whoever's going to evaluate it for you, they're kind of up to speed. And again, so you're not wasting your time. You also want to ask, if they say yes, there is a will, you want to ask, is there a copy? And reason being, this might sound silly, but I've had it where people will come to me and they say, yeah, my brother was really sick. I've been taking care of him for 25 years. His kids abandoned him. They didn't have anything to do with him. He told me he had everything. He was going to leave everything to me. He has it. He wrote it down somewhere. I'm not sure where it is. And I say, okay, well, you're the brother, so even though his kids abandoned him, they're still going to get the property. Do you know where it's at? No, but I know he, And if they don't have a copy of it, there's not much I can do. There's not I get asked this a lot. There's not a master database where I can go find out where the wills are. So there's not I can't go to www.will.com and I don't know what that probably sells wills, but whatever that is, and look up and find out where it is. Because a will, basically, again, legal requirements aside, I could take this piece of paper, say I leave everything to so-and-so, I could put it in this drawer, and that could be a valid will, and nobody's going to know where that's at.
Does it need to be notarized or something?
There are it doesn't necessarily have to. I mean, there's requirements. It doesn't necessarily have to be notarized. It needs to be witnessed. There's other requirements to it.
And it's not recorded in the-
It's not recorded. No, it's not recorded. So you want to keep the original somewhere safe. Copies work, but you do need to have you want to keep the original as well. So ask, was there a will? Can you get a copy of it? Again, just to make sure you're speaking with the right person. The second question I always advise realtors to ask is, when you're speaking with them, what was your relationship to the person who passed away? And you want to be, in your mind, you want to see, are they the spouse? Are they the child? Are they the brother? And the reason is, in Florida, if there is no will, there's a hierarchy of who's going to inherit what. So in this example, there's no will. So let's say, Sarah passes away, her husband had passed away many years ago. If there's no will, it would go to her children. If there's no children, it would go to her parents. If there's no parents, it would go to her brothers and sisters, then to the grandparents, and on and on and on. So if you're speaking with somebody, and again, this is common in Miami, where you're living with a cousin, and you're speaking with a cousin, you'd have to go down a lot of people before it would ever get to the cousin. And so you want to make sure, again, for your sake, that you're speaking with someone who's relatively close in relationship to the family. Does that make sense? Okay. All right, so let's say now you've identified, and so again, this is not to say, okay, well now send it to your attorney, but you do want, your job again is not to read the will and interpret all that. You will use, I would advise you to use a probate attorney, but this is all useful for just, making sure you're working with the right person. Okay, so now you've decided that you're working with the right person. The attorney said, hey, yeah, that's going to be the personal representative. So, like I said earlier, the personal representative is the person who has the authority to sell the property. And the personal representative is appointed by the court. So even if someone has a will and the will says, I, Justin Stivers, appoint Jonathan as my personal representative. Even though there's a will, it has to go to court, and there has to be a document from the judge that says Jonathan is the personal representative. And a lot of people come to me and they say, hey, I've got this will, I'm the personal representative. And I say, you are in that piece of paper, but we have to give that to the judge to have him or her now say that you're the personal representative.
What happens if will shows up and there's a divorce? Is that voided?
Technically, yes. Yeah. Yeah, good question. But that you'd have to get the will approved by the court. Get the will. You have to submit the will to the judge, and again, the judge is going to make sure it's and this is where probate can get complicated if there were 2 wills or 3 wills, and brother and sister each have a will, and then you're fighting. That happens a fair amount, or increasing amount. Okay, so we've determined. We've got the personal representative, or we're in the process of getting the personal representative appointed. But obviously, you guys want to get them signed up as a client. You want to sign a listing agreement with them. So this is where it's a little bit tricky and there's a little bit of gray area. I know you're John, but I always use John in my examples. It's just like the easiest. So in this case, John John doesn't have any, John is going to be the personal representative. We know he's, let's say there's a will, the will says John is personal representative, but we don't have that piece of paper from the court yet. But you guys want him to sign the listing agreement because you don't want him to go sign up with somebody else. So here's the language that I always say to put in the listing agreement. I always say, John Smith as proposed personal representative, okay? And the reason is he's not yet personal representative. He's going to be the personal representative, so we want to put that language, John Smith as proposed personal representative. You could write the whole thing out and you could put John Smith as proposed personal representative of the estate of whoever's passed away, but you could just put that proposed language in there. That just, John doesn't have any authority yet to sell the property. We think he's going to when he becomes personal representative. This just gives you a little bit of peace of mind and kind of locks him in to go ahead and have that listing agreement. Now we get him appointed as personal representative. All right, so now we got the piece of paper from the court that says he's personal representative. Now you guys are ready to list, sell the property and all of that. You get a contract. Here's the language now is going to shift from when he signs that contract, it's going to be John Smith as personal representative of the estate of whoever. At this point now we're saying he's personal representative, so he can sign, any contract, he can sign any closing documents, and all of that. Any questions? I know it's a little, yes ma'am.
And although the personal representative on the will, it always has to go to the court?
Yes.
Oh.
Yes. So now, yeah,
How long the person stays?
next section, I'm gonna get to that.
I do want to make a comment because my spidey sense is tingling.
Yeah,
And
sure.
I just want to make sure that you guys know that we, as far as Coldwell Banker is concerned, until that person is assigned personal representative, we really should not be asking them to sign a listing agreement.
Okay,
Because
yeah.
we really don't know, if that's going to take
Yeah.
place or not. So I would feel more
Yeah.
comfortable to make sure that we have, some letter, I think their letter of administration or something to
Yeah.
that effect. Until that person gets assigned officially by the judge, we have no business marketing a property, on the MLS where that person still doesn't have the authority to sell it.
Well, and I agree with that. I agree that, and obviously he's the boss, so listen to whatever he says. But you should not list or try to sell it until they're appointed as personal representative. Absolutely, because they have no authority to sell it. Because they might be inheriting the property, but until the court says that they have the authority to sign the documents, they can't do anything.
But can they sign the agreement at least?
Yeah.
So you
That's
make
what
sure that they don't go anywhere?
I defer to him.
See, I mean, that's the thing, you can have them sign the agreement to, I guess, tie them to you, to Coldwell Banker, but we're not gonna be putting it, or we shouldn't be putting it on the MLS. Exactly.
Yeah.
The name could be power of attorney?
No.
Well, no, because the
No.
power of attorney, once
Yeah.
the person's deceased, becomes invalid. So it has to be,
Yeah.
a personal representative appointed by the court.
Yeah, so let me, because if you heard, you cannot market, you can't list it, don't put it on the MLS until you have that personal representative appointed. Because you could get yourself in trouble, but you could get and here's a perfect example of that. That's exactly what happened with the second example of Maida and Jesus. The realtor didn't wait till she was appointed as personal representative, didn't do the probate, marketed it, went under contract, and fortunately the buyer was patient and didn't do anything, but they wasted 4 or 5 months in the process. So in theory, if you market it and this person doesn't have the authority to sell the property, so you're basically saying that this person can sell it when they can't. So you do want to wait until there is a personal representative appointed. I think the difference is, and maybe what I was saying in the beginning was that you could have them at least sign up with Coldwell Banker, but just not listed. Is that accurate
Right.
with you? Okay.
Yeah.
Yeah, so that's the difference. You could have them say, they're going to sign up with you, but don't start marketing it. Don't put it on the MLS. Don't do any of that.
But the personal representative is not necessarily the one who inherits the property, so, right?
Not necessarily, no.
Okay. So does it make sense that a representative starts selling a property when they're not the ones inherited.
Well, so good question. The personal representative is the one who is designated to act on behalf of the person who died. So even if they're not inheriting it, they're still if they're named as personal representative, they are the ones who are going to sell it. It's not just the person who's inheriting it. It's the person who's named as personal representative.
So could it be that the personal representative is being assigned to sell the home for the eventual heir?
Yeah. Yeah, so what happens, I think, let me make sure, so what happens is, or what can happen, I'm trying to think of a recent example, but let's say, John names his friend Roger as personal representative, but John names his daughter Sarah to inherit the property, okay? Okay, so Roger is the personal representative, Sarah is going to inherit it, Roger, as the personal representative, is going to sell it, and then Sarah gets the money from it. So you can have, and I would say 9 times out of 10, most people name their children as the personal representative, usually is what people do. Some people name their attorneys, that's not very common. Some people name a friend, but yeah, it depends.
In a case, I'm trying to remember all the details of it, but there were several siblings, and one of them was named representative, but it never came to fruition because there were rivalries going on in the family, and then if I remember correctly, one of them was trying to buy it themselves, one of the siblings, buy out the other ones, and so it just got complicated. And
Okay, yeah.
so the personal representative really never ended up being, representing.
Yeah, I think the moral of the story is that if someone died and they didn't have it in a trust and they didn't have one of those deeds, no one's going to be able to sell or buy that property without doing this process. So that's kind of and a lot of people, want to circumvent that. They want to go around that. They say, oh yeah, well, I'll just pay cash for it. Or, but to have clean title, if you want, to actually do the sale properly, you have to do this process. I don't know if that, but yeah, you do have sibling rivalries, which I'll get into, length of probate now, and that can make the probate go a lot longer. And like I said, just to give you guys some examples, I've seen, the two most common, or the most common way to challenge a will, two most common challenges are if the will was not executed properly, and if the person who did the will didn't have capacity at the time they made the will. So, sadly, if, someone may have been suffering from Alzheimer's or dementia or something like that, and their kids or whoever had them sign a piece of paper, and then you have a fight, and that takes a lot longer. But that's just a side. Okay, so probably the most important, the question you're going to get asked, and probably the question that you all want to know, is how long does probate take? Because I'm sure you guys have had horror stories or worked with people where the probate did take a long time. So how long does probate take? When can you sell the property? When can you market the property and do all of that? So I'm going to give you two situations, or one piece of information, and then give you two different timelines. So the thing I guess another question you should ask is when the person died, and the key number is 2 years. So there's two timelines. If the person died over 2 years ago from when the probate was started, or if the person died within 2 years. So we'll talk about the first one. So let's say in this first example, let's say the probate was opened in 2019, but the person died in 2016. Okay, so it's been more than 2 years from the date of death to when the probate was open. All right, in most probates, again, there are exceptions. I would say on average, the personal representative is going to be appointed within 20 to 45 days. That's at least our goal. It can take longer, but usually, and it can be a little bit sooner, a little bit longer, depending on the county, depending on the judge and whatnot. But within 20 to 45 days of us or your attorney getting the file, opening it, and starting the probate, within 20 to 45 days, the personal representative can be appointed. And so what does that mean when the personal representative is appointed? you guys can sell the property. Okay, you guys can start marketing, selling the property. So let's say, just to make the math easy, let's say that someone comes to our office, they get us all the documents we need, we file the case on January 1st, we get the personal representative appointed on January 30th, 31 days in January? 31, yeah, January 31st. February 1st, you guys can start trying to sell the property. The sale generally, usually, almost always, generally always, has to be approved by the judge. So let's say that you've already got a buyer lined up, they're ready to purchase it. So on February 1st, all you do is just have the personal representative sign the contract. You give the contract to me, I take that to the judge. It's probably gonna be another 15 to 30 days to get that approved. So let's just say on average, 2.5 to 3 months, and the property will be sold. I mean, really, it only took you guys a month, but yes, sir.
You're saying, once the personal representative has been designated, and they put the property on the market, we receive an offer, have them sign it, we bring it to the judge. Once we bring it to the judge, it's gonna take how long?
I said it from when you bring an offer to me, I have to get a hearing date usually from the judge. I have to go in front of the judge, so I can't just walk into the court and say, hey, judge, sign this.
Judges are there every Tuesday and Thursday, you just gotta get in line for.
Ex parte here, not all judges and not all counties.
Not all anything, but I'm just saying, why is it taking 30, 45 days? Because that goes against what I personally witnessed, and that's why I'm asking you.
Right, well,
Usually these guys are available, if you make an attempt to go up there, find it in your schedule to get up there right away, this can get done within the 30-day period of time, which really doesn't take you out of contract like you got a mortgage contingency clause that lasts for 30 days. That's usually executed by the judge within a 30-day period. There's no offset time to time or anything else.
if you've had that experience, fantastic. Not all judges have ex parte walk-in on Tuesday and Thursday, so that's why this is not every single example will be like this. So I'm giving you an average. So if yes, you get a contract on Monday and you're in front of Judge Muir, and on Tuesday at 8:30 a.m. you can go and walk it in. She could sign it. It took you 1 day. So I'm giving you an average on all of the probates that we've done, and generally it's going to take about 30 days more or less to get in front of the judge, to have the judge sign it. Could take a little bit sooner, could take a little bit later, but if the person had died over 2 years ago, I would say on average you're looking at about 2 months, 2 to 3 months from when the probate was open. Okay, so the second situation is if the person has died within that 2 years. So let's say we open the probate January 2019, but the person died in 2018, it's going to take a little bit longer. Generally, it's going to take a little bit longer. Okay, so if it was within 2 years, you're generally going to have to wait a 3-month period before the property can be sold. So we're taking about 20 to 45 days to have the personal representative appointed. So that's let's just say month 1. Now we've got month 2, month 3, and month 4 where we're waiting. And during that, and the reason we're waiting is there's a period called notice to creditors, where let's say someone dies and they owed money to American Express, they owed money to Baptist Health, wherever. During those 3 months, they're going to come to us as the attorney and say, John who died, they owed us all this money. We fight with them, deal with those creditors. And generally, almost without exception, you're going to have to wait those 3 months. And then so during month 5, you can sell the property. You could go ahead and list it. You could go ahead and list it after that month 1 when the personal representative has been appointed. But you might not be able to sell it during month 2, month 3, and month 4 until that creditor period has expired. I'm going to talk about an exception in a minute, but yes.
What about when they owe money to the IRS?
Well, the IRS could just take the property. They could, what's the, I don't understand specifically.
Taxes.
There's a lien. But
There's a lien.
Yeah, so there'd be a lien on someone's going to have to deal with that, like any other. Yeah. So during those 3 months, you're probably not going to be able to sell it. Now, there are situations, and again, this is county specific, this is judge specific. But let's say the property in his example earlier where there's a mortgage on it, and it's not being paid, and the kids don't have the money to pay it, and if you have to, and it's already in foreclosure, and you don't have 3 months to wait, because if you wait those 3 months, the property's gonna be lost in foreclosure. Generally what you can do, what we try to do, is we'll go to the judge and say, listen, we have to sell this property right now, or else it's going to be sold, and the heirs are gonna lose out. And most judges will say, okay, we'll allow it under these circumstances. We put the proceeds into essentially what's similar to an escrow account. You all would already get paid. Your money's not tied up. You all already get paid. And that money would just be held in essentially an escrow account until the end of that 3 months. So in the example where it's where someone has died sooner, it could in theory take a little bit longer. I would say, I mean, again, this all depends on also how quickly can you sell the property, right? So just because you can sell the property doesn't mean you're going to have a buyer right away. But if you've already got someone who's lined up ready to go, I would say on average in most probate cases it should take between 3 and 6 months, more or less, from when the probate was open to when you actually get to the closing table. It can certainly take longer. I'm working on one with John right now, and not for our fault. I don't think it is taking long, but there can be circumstances where they do take long. Did you have a question?
Yes. Is it possible to sell that property in short sale? Was it for foreclosure and there's not much time to wait to sell it as regularly?
Well, there's probably not, maybe, but there probably wouldn't be a benefit to doing it because the owner's died, and usually the benefit of doing a short sale is to keep your credit intact, right? So if they're not going to get any money, because the money's just going to get paid to the lender, there's not really any reason to do a short sale.
Can you explain the difference between why for 2 years, creditors after 2 years?
So it's a law. It's just it's a law that says if the probate is opened after 2 years from when the person had died, any creditor is barred, forbidden. They can't make a claim on the estate. They can't go after any money. So, but if you file it within 2 years, they can. Does that? Yeah.
I've had an experience where basically you have to give them, I guess it's competitive market analysis, and I've always thought that went to the judge to have them look at it, but does it go to the judge, or does it just go to you and to tell them that it's a proper value for the property?
Again, county judge specific. If there's nobody, quote unquote, on the other side, if there's no fighting, if let's say I'm the only attorney and all siblings are in agreement, most judges aren't going to look. I'm just going to write. You'll have sent me the CMA, and I've looked at it. It looks good to me, and I'm just going to ask. Most judges aren't going to read the CMA, most likely.
How much did it cost to do a probate?
Okay, so cost, that's probably, and then I know we're running out of time. So cost, probably the second question that will come up. It depends. So there's really 3 ways that attorneys will charge. Some of them will charge an hourly rate, and that can range. Some will charge a percentage of the estate. So in Florida, you could charge up to about 3% of whatever the estate is worth, and then some will charge a flat fee. So us personally, we generally charge a flat fee, except for litigation where we're fighting over wills, and then we would probably charge hourly. But generally flat fee. I would say on the low end, probably $3,500 for a probate. On the higher end, probably $10,000 is probably a range of where. How do people get paid? Again, it depends. Some people will get paid from the sale of the property. Some people will front the costs. If there are other assets in the estate, like a bank account, they'll get paid directly from the bank account. So again, it just kind of depends. Okay, and then last section. So probate, again, I always get at the end, everyone's kind of like exhausted, like, oh man, probate sounds awful, like I don't want to do it. But the truth is, it's probably not something that you're only going to do, probate listings. I do know one realtor who she does like 80% of her work is only probate, and that's all she does. But for the most part, this is probably just something that's going to come up maybe once in a while. I think in your instance, 20 years and you've never had, so some of you guys have been doing this for a while and it's never come up, so it may not come up. But I think there is a good market for it. I do think that there is an opportunity for it. Again, just by being able to use maybe some of these definitions, give an estimate of how long it's gonna take, I think you'll stand out from a lot of other competition when you're competing for the listing agreement. I think, and not just because I do this, but truthfully, attorneys are great referral sources for you all, because in most of the probates that we do, we're gonna have a piece of property that has to be sold, right? So most of them, and some of our clients already have realtors. I mean, it's Florida. I mean, there's a realtor everywhere, just like there's an attorney everywhere. But some of them, already have, or maybe they don't want to sell it, they don't want to rent it, but probate attorneys are probably good referral sources for you all. One helpful, kind of like secret, which I tell people, is if you go to the tax roll, and if in the owner where it says owner, if you were to type in estate of, just write the word estate of, you're gonna get a fair amount of potential property. You guys have done this, I think. And you'll just get a list of, not all of the properties, but a fair amount of the properties that are owned by estates, which means they've got to go through probate, so you've got their address right there. You could do direct mailers going directly to their house. The one thing with probate, I always tell realtors, remember, this is, while it is, your job is to sell the property, you do want to advertise quick, cash buyers if you've got them and all of that. Remember, this is, someone has died. That is kind of the trigger for this. So you never really know if you're dealing with somebody, I mean, regardless, where, it was a parent who just passed away, it was their family home, they don't necessarily want to sell it, but they have to because they can't keep it. So when you are marketing for it, you do want to add a little bit of empathy as much as you can, and try to keep that in mind. And then lastly, the other thing you can do, I mean, there are, I don't know specifically, but I only know because I'm on these lists, where you can purchase lists to find out who the personal representative is, who the attorney is, and then you can, again, do emails, direct mail to them to try to find some of these listings. That's all I have, unless you guys have any other questions or
What
things.
happens when there is a couple that they're married but only one buys the property under their name? What happens if the person passes away, he or she? Does they inherit the husband or the wife, inherit the house?
Generally, will they inherit it?
Yeah, if
Yeah.
one of them pass away, the other one get the house?
They will get the house, and it depends. Sometimes you'll still have to do a probate for it. Where that happens a lot is if, a second marriage, someone purchased the property first, and they never redid the deed, they might have to do a probate and put it in the surviving spouse's name. We've had that.
It's commercial.
You just go by the chain of ownership or the
Yeah.
commercial property?
Yeah. Yes, sir.
When would you not need to go to probate?
A trust, joint tenants with the right of survivorship. Generally, companies, ownership of a company is not going to have to go through probate, and they're going to have their own kind of bylaws and things that will say what happens with the property. That's pretty much it. Yeah.
About a remainder, man.
Yeah, a remain. Yeah. I guess the answer is having the proper deed, right? Having the deed done properly can avoid it. Awesome. So I've got. You have a question? Yeah. Actually.
Real quick,
Oh, yeah.
I have a testimonial for Justin.
You guys already.
Our job being realtors, it's not easy, as we all know, right? There's a lot of variables that take into play. It's always nice when you have a lender that you can go to and you know you don't have to follow up. It's always nice when there's a title company you can give a file to, and you know you don't have to follow up and make sure everything's going the way it should be going, and you can continue your job, and your job is to go out and make business and find more clients and get that turnover, find more listings and buyers and so forth. So when it comes to probate, it involves a separate variable that if you don't find the right person, you need to call and follow up because you haven't heard from them, and follow up and takes up all your time of doing what you should be doing and finding listings. And Justin's the one that we go to because we know we don't need to continue calling. Hey, what's going on with this file? What's going on with this file? Because he's prompt, he emails us before we think about emailing him, and he follows up with our clients before we even need to. So you go to Justin, and you know that file's taken
All right.
care of.
Awesome.
So
Thank
it's
you.
great.
Thank you. Thank you. Very nice. Very nice.
I'm curious as to that agent that does 80% of her business in probate. Is it because she's is she married to a probate attorney?
No.
Does she
So-
have referral alliances
I
with
have-
all these probate attorneys?
Do you want name and everything?
Oh, I mean, I just want to know how
Yeah,
she
she-
developed that so that they
so-
can go and develop that.
Yeah, so what she's done is primarily through attorneys. So she's with Keller Williams. She's Melanie is her name. She's on the beach, and what she does, and full disclosure, I've never done any work with her. So, but I know some of her main things are sponsoring events for attorneys. So there is a monthly luncheon at the courthouse, the probate courthouse, once a month. For probate attorneys and the probate judges. She's very active in that, so she goes to that event, and she normally does, I don't know, a couple happy hours a year where she invites, probate attorneys and whatnot. And again, how many, and she's literally the only realtor at that event, right? And so even though that there's one already doing it, that's still pretty small numbers, in the grand scheme of things. But I don't know specifically how but I think that's.
No, but that was
Yeah,
very
I think
helpful.
that's how she. I think
Take
that's how she
heed,
does
everyone.
it.
Take heed.
Yeah, I think that's how she does it. Awesome. All right. Well,